Thank you. Judgment on the reference, the Agricultural Sector Wales Bill.
Lord Reid will summarise the decision of the Court.
The Attorney-General for England and Wales has referred to this Court the question whether a bill passed by the National Assembly of Wales is within its legislative competence. This Court has the function of deciding such questions under the Government of Wales Act of 2006. The bill in question is the Agricultural Sector Wales Bill of 2013, which was passed on the 17th of July 2013. The main purpose of the bill is to establish a scheme for the regulation of agricultural wages in Wales. Such a scheme existed for England and Wales until it was abolished by the UK Parliament under the Enterprise and Regulatory Reform Act of 2013. Under the Government of Wales Act, the Welsh Assembly is empowered to make legislation which relates to subjects listed in Schedule 7 to the Act and does not fall within any of the exceptions specified in the schedule. One of the subjects listed in the schedule is agriculture. The Act directs that the question whether a provision relates to a subject is to be determined by reference to the purpose of a provision having regard to its effect. The Consul-General for Wales argues that the bill relates to agriculture. The Attorney-General argues that in reality the bill relates to employment and industrial relations. Those subjects are not, however, specified as exceptions, although there is a much more limited exception in the general area of employment relating to occupational pension schemes. This Court unanimously holds that the bill is within the legislative competence of the Assembly, for reasons which are set out in a judgment written jointly by Lord Thomas and myself. The first question is whether the bill relates to agriculture in the light of its purpose and having regard to its effect. The main purpose of the bill is to regulate agricultural wages so that the agricultural industry in Wales will be supported and protected. The bill will have a direct effect on the agricultural industry in Wales. In these circumstances, following the approach laid down in the Government of Wales Act, the Court concludes that the bill relates to agriculture. Does it matter that the bill might also be classified as relating to employment and industrial relations? The Court concludes that it does not. Legislation can be classified in many ways. In the present context, the Court has to apply the scheme of classification laid down in the Government of Wales Act, a scheme which lists agriculture as a subject which is devolved, but does not contain any mention of employment or industrial relations. The question the Court has to answer under the Act is whether the bill relates to agriculture. The question whether it relates to employment or industrial relations simply does not arise. The Court also notes that the Act contains a specific exception in respect of one particular aspect of employment, namely occupational pension schemes, and that specific exception is difficult to reconcile with the argument that the subject of employment generally should be regarded as beyond the limits of the Assembly's powers.
Thank you. The Court will now adjourn.